The defendant, Mr. Orenthal James Simpson, is now afforded an opportunity to argue the case, if you will. But I'm not going to argue with you, ladies and gentlemen. What I'm going to do is to try and discuss the reasonable inferences which I feel can be drawn from this evidence. At the outset, let me join with the others in thanking you for the service that you've rendered. You are truly a marvelous jury, the longest serving jury in Los Angeles County, perhaps the most patient and healthy jury we've ever seen. I hope that your health and your good health continues. We met approximately 1 year and 1 day ago on September 26, 1994. I guess we've been together longer than some relationships, as it were.
All right, so when you're doing a closing, criminal closing, you want to keep it light and short when you're doing the thanking of folks. A lot of people that I watch, they get up there and they give a 5, sometimes 10-minute discussion and thanking the jury and trying to ingratiate themselves with the jury. Based on jury feedback and my personal opinion and experience, you want to get to the point. If it's a 2 or 3 day trial, don't assume that the jury likes you. Don't assume that they want to hear you thanking them. They generally want to get home. Now, Johnny's right. This has been a year. They were in court for a year, so they do have a relationship with some of these jurors. They've been together for a full year, and he keeps it short and gets on with the closing.
But we've had a unique relationship in this matter in that you've been the judges of the facts. We have been advocates on both sides. The judge has been the judge of the law.
I'm not going to jump in too much as we go, but I want to make this point. You should always, in your closing as a criminal defense lawyer, even in civil cases, make it clear that you are just an advocate. Don't get up there and try to act like you're a witness. Don't try to vouch for people's credibility or truthfulness like you know them. That's bad. I see that happen a lot. But let them know, hey, I'm the defense lawyer. I speak for the defense. They are the prosecutor. They speak for the government. And we're not witnesses.
We all understand our various roles in this endeavor that I'm going to call a journey toward justice.
That's his theme, journey towards justice.
That's what we're going to be talking about this afternoon as I seek to address you. The final test of your service as jurors will not lie in the fact that you've stayed here more than a year, but will lie in the quality of the verdict that you render and whether or not that verdict bespeaks justice as we move towards justice. Now, you'll recall during a process called voir dire examination, each of you were thoroughly questioned by the lawyers. You probably thought, gee, I wish they'd leave me alone. But you understood, I'm sure, that this is very serious business. Our client, Mr. Orenthal James Simpson, is on trial for his life. And so we had to be very, very careful, both sides, in trying to get people who could be fair to both sides. You'll recall those questions, that you keep an open mind, which I hope you still have even to this day, that you wouldn't be swayed by sympathy for or passion against either side in this case, that you would give both sides of this lawsuit the benefit of your individual opinion. No one can tell you what the facts are. That's going to be your job to determine. It's not a question of age or experience. We talked about that. This is one of those jobs where you kind of learn on the job. And so it's important that you fully understand that. And that's why voir dire was so very important, as we ask you all of those questions before you were sequestered, before you were actually picked. Now, each of you filled out the questionnaire, and you answered the questions honestly, I'm sure. You know, Cicero said a long time ago that he who violates his oath profanes the divinity of faith itself. And of course, both sides of this lawsuit have faith.
He also weaves in this idea of God and faith. I think you have to be careful. doing that because you could ostracize a lot of people, especially in a case like this. I also think that this is my opinion. This is 2024. You kind of want to start getting to the point more quickly. I think this modern generation is not going to sit through a 5, 6, 7 hour closing argument. But this was in the 90s, and he has his own style, which I can't knock. I think this is one of the best closings that I've ever seen online or in court anywhere.
That you live up to your promises, and I'm sure you'll do that. You know, Abraham Lincoln said that jury service is the highest act of citizenship. So if it's any consolation to you, you've been involved in that very highest act of citizenship. And so again, we applaud you and we thank you as we move toward justice. One other entity or group of ladies, or two ladies that I should thank, are our marvelous court reporters. They have been patient with us. They've been here from the very beginning. We very much appreciate them and their services. And I especially appreciate them.
Move along.
Because sometimes I speak rather rapidly, and they have a tough time keeping up with me. So I trust that today, if I start to speak too fast in my zeal, Ms. Moxon and Chris will bring that to my attention. I'm sure they will. Now, in the course of this process where we're discussing the reasonable inferences of the evidence, I ask you to remember that we're all advocates. We're all officers of this court. I will recall the evidence and speak about the evidence. Should I misstate that evidence, please don't hold that against Mr. Simpson. I will never intentionally do that. In fact, I think you'll find that during my presentation, unlike my learned colleagues on the other side, I'm going to read you testimony, what the witnesses actually said, so there'll be no misunderstanding about what was said about certain key things.
I think it's good if you have the transcripts to hit that. And again, he's reiterating that theme that he is not a witness. He's arguing and presenting the facts on which they must make a decision. And the other side, they aren't witnesses either. They're just advocates. So I think that's a good theme to keep up.
But remember that we're all advocates. And I think it was Ms. Clark who said, saying it so doesn't make it so. I think that applies very much to their arguments. Ultimately, it's what you determine to be the facts. It's what's going to be important. And all of us will live with that. You are empowered to do justice. You are empowered to ensure that this great system of ours works. Listen for a moment, will you, please? One of my favorite people in history is the great Frederick Douglass. He said shortly after the slaves were freed, quote, "In a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny." This marvelous statement was made more than 100 years ago. It's an ideal worth striving for, and one that we still strive for. We haven't reached this goal yet. In the country of ours, we're trying. With a jury such as this, we hope we can do that in this particular case. Now, in this case, you're aware that we represent Mr. Orenthal James Simpson. The prosecution never calls him Mr. Orenthal James Simpson. They call him defendant. I want to tell you right at the outset that Orenthal James Simpson, like all defendants, is presumed to be innocent. He's entitled to the same dignity and respect as all the rest of us. As he sits over there now, he's cloaked in a presumption of innocence.
Now, you're going to see this theme come up quite a bit too. The cloak of innocence, the presumption of innocence. You have to hit that hard when you are defending someone and giving a closing argument. The other thing that he did, and all these things come out in my book, Kick-Ass Closings. I use a lot of the great closings from the last 50, 60 years. But one of the portions is this idea of presumption of innocence and also the concept of dehumanizing the defendant. He brings this up several times in his closing, how they dehumanize O.J. Simpson and they try to make him like he's just a name, or he's a murderer. He's anything but his actual name. So that's a tactic that prosecutors use in a lot of cases where they do not call the person accused by their name. They try to dehumanize him. So I think it's a smart thing to bring that up if it's happening in your case. Now, you don't want to do that in every case. It is something good to hit on when they are intentionally dehumanizing your client and hoping that the jury sees him more of him or her as a bad person, as a bad human or subhuman. It's then easier to convict someone if they're viewed as a bad person, a subhuman, a perpetrator, a rapist, things like that.
You will determine the facts of whether or not he's set free to walk out those doors or whether he spends the rest of his life in prison. But he's Orenthal James Simpson. He's not just the defendant. And we on the defense are proud and consider it a privilege to have been part of representing him in this exercise and this journey toward justice.
You can imagine the stress of OJ right now, though, because remember, he's in jail.
Finally, I apologize to you.
Let me pause right there. Never sit like this gentleman, this prosecutor right here is sitting. Or either one of the prosecutors. This is lazy. This shows incompetency. It shows you don't give a crap. I'm very strict with my co-counsels and my client on this stuff. Sit up straight, act like you're reading something, act like you're engaged, act like you're listening. Lounging back in a chair with your suit unbuttoned, looking all disheveled, it looks lazy, it looks sloppy. And that sloppiness is something that happens throughout this trial. If you watch the whole trial, but I've watched many, many portions of it, these two don't stand up half the time when they're objecting. They seem disheveled. They just seem like they don't give a crap, and they look lazy and incompetent. And I think everything in a serious case like this, everything together makes a difference when you're trying to persuade the jury, because it's advocacy. If you look like you're about to take a nap, not good.
For the length that this journey is taken. But you know, when you're seeking justice, there are no shortcuts. If you were to trade places with either side, you'd want someone who'd fight hard for you and vigorously, especially who was a person who had maintained their innocence from the very beginning of the proceedings. Some of you in voir dire talked about that you've been involved in other cases where you felt the lawyers didn't stand up. Well, I certainly hope that in this case, on both sides, you felt the lawyers did their best to represent their respective positions, and we will continue, I'm sure, to do that, so that, although I apologize for the length of the trial, I hope and I trust that you will understand that in a journey toward justice, there is no shortcut.
Now, you notice he talked about in voir dire, some of the people said that they saw other cases or knew of other lawyers who didn't do their job. I'll tell you from doing this for over 20 years, trying many, many cases, the jury expects you to do your job as a lawyer. They expect you to put up a fight. They expect you to be professional. They want you to be professional, even if you're representing a criminal. You're sitting there lounging at a table and you look unprepared and incompetent. It reflects poorly on you. They expect you to do your job and do it diligently and zealously. And they want to see a show. And they're going to watch a bunch of lazy ass lawyers, mumbling their way through closings and openings and objections. No, O.J. Simpson team put on a brilliant defense. They did a great job. They looked like they knew what they're doing. They seemed enthusiastic. And whether you like O.J. or not, he got a $25 million defense.
Finally, with regard to your responsibilities, we ask you at the very beginning to don't compromise. This is not a case for the timid or the weak of heart. This is not a case for the naive. This is a case for courageous citizens who believe in the Constitution. And while I'm talking about the Constitution, think with me for a moment. How many times you heard my learned adversaries say, the defense didn't prove, the defense didn't do this, the defense didn't do that.
All right, now he's going to go into a very crucial moment in every closing. You have to hit burden shifting. the government tries to directly or indirectly shift the burden. I know that can get a mistrial, that can get the case overturned on an appeal, but they do it very subtly and in very sophisticated ways in my experience. So you have to call them out on that. One of my first slides in my closing arguments and one of the first chapters in the book, Kick-Ass Closings, deals with shutting down burden shifting. You got to put these things on the table. So instead of thanking the jury for 25 minutes like some lawyers do, mumbling around for the first 15 minutes, throw burden shifting in there and highlight it and make it clear to them that they can't do it. It's wrong. It's illegal. And if you hear someone doing that in the deliberation room, shut them down and remind them that that's improper. That's what Johnnie does here.
Remember, back in voir dire, what did the judge tell us? Judge Ito said the defense could sit here and do absolutely nothing. One of you is from Missouri, and he reminded you, who's from Missouri here? Say to the prosecution, you show us. Now, we didn't do that. But we don't have an obligation, as you'll see. You've heard from the jury's instructions, and at the end, I will show you some others. We don't have to do anything. We don't have to prove anything. This is the prosecution's burden. And we can't let them turn the Constitution on its head. We can't let them.
I mean, Chris Darden here looks like he's about
burden.
to fall asleep if he's not sleeping at the table.
One of my jobs is to remind you of that and to remind them of that.
Unacceptable. Keep your hand off your face, too, if you're one of the lawyers.
They must prove Mr. Simpson guilty beyond a reasonable doubt and to a moral certainty, and we will talk about what a reasonable doubt means. And so now, as we have this opportunity to analyze the facts of the case, I agree with one thing that Mr. Darden said. To this task, I ask you to bring your common sense. Collectively, the 14 of you have more than 500 years of experience. I know you're all young, but you multiply by 14, you won't hold that against me, I don't think. 500 years of experience. You didn't leave your common sense out in that hallway when you came in here. And we're going to ask you to apply it to the facts of this case. I'd like to comment and to compliment Ms. Clark and Mr. Darden on what I thought were fine arguments yesterday. I don't agree with much of what they said. But I listened intently, as I hope you'll do with me. And together, hopefully, these discussions are going to be helpful to you in trying to arrive at a decision.
Look like you give a damn, buddy.
In this case, where you don't compromise, where you don't do violence to your conscience, but you do the right thing. And you are the ones who are empowered to determine what is the right thing. Let me ask each of you a question. Have you ever in your life been falsely accused of something? Have you ever been falsely accused? Have you had to sit there and take it and watch the proceedings and wait and wait and wait, all the while knowing you didn't do it? All you could do during such a process is to really maintain your dignity. Isn't that correct? Knowing that you were innocent, but maintaining your dignity and remembering always that all you're left with after a crisis is your conduct during it. So that's another reason why we're proud to represent this man who's maintained his innocence and has conducted himself with dignity throughout these proceedings. Now, last night, as I thought about the arguments of my colleagues, two words came to mind.
Now, what he's about to do, you can use in almost any serious felony level trial, even in some civil trials. And I use this all the time. I have these transcripts, and this is actually also in my book. And it's talking about prosecutors that are cynical and speculative. I think this is brilliant.
And I asked my wife this morning to get the dictionary out and look up two words. The two words were speculative and cynical. Let me see if I can get those words that she got from me.
His wife probably didn't look that up in the morning. She probably never discussed this.
I asked her.
This is the type of material you have to have
case.
prepared. This is the theater, okay? So you have these definitions that your wife or best friend or your co-counsel or whatever gave you, and you act like, oh, I looked up these words and here's what they mean, cynical and speculative. I bet you Johnny has used these lines probably dozens and dozens of times in other cases, because I know I have.
To go to Webster's, and I want you to tell me what does it mean to speculate? What does it mean to be cynical? As I thought about my colleagues' arguments and their approach to this case and their view of this case. Cynical is described as contemptuously distrustful of human nature and motives, gloomy, distrustful view of life.
Cynical and speculative, gloomy, distrustful view of life. He's talking about Darden and Marcia Clark. And he hits on their cynical and speculative views of the world. They think everyone's bad, everyone's guilty, and he uses that against them.
And to speculate, to engage in conjecture and to surmise, or is to take to be the truth on the basis of insufficient evidence. I mentioned those two definitions to you because I felt that much of what we heard yesterday and again this morning was mere speculation. Understand this, ladies and gentlemen, that none of us in this courtroom were out at 875 Bundy on June 12th, 1994, after 10:30 or 10:45 in the evening.
Again.
So that everything we say to you is our best effort to piece together what took place in this case. When people theorize about things that may have been and talk to you about short fuses, you're going to see that's just that. It's speculation. People see things that are totally cynical. Maybe that's their view of the world. Not everybody shares that view.
So again, we're going to see this theme running throughout. He not only hits on the cynical and speculative nature, but he reminds them repeatedly that they are not witnesses. He doesn't use those exact words, but he uses similar phrases like, none of us were out on the road that night. None of us were there. We're just advocates, to let the jury know that they are trying to piece together information that they heard from witnesses, but the lawyers aren't actual witnesses in the case. Although Marcia acts like she was when she's up there telling her theories in her closing argument. Again, you have to keep reminding them of that.
Now, in this case, and this is a homicide case and a very, very, very serious case. And of course, it's important for us to understand that. It is a sad fact that in American society, a large number of people are murdered each year. Violence, unfortunately, has become a way of life in America. And so when this sort of tragedy does in fact happen, it becomes the business of the police to step up and to step in and to take charge of the matter. A good, efficient, competent, non-corrupt police department will carefully set about the business of investigating homicides.
Now, this is another major theme. A good, competent, non-corrupt law enforcement agency. So this is another theme that you can use if you are dealing with cops that are not good, that are corrupt, that are incompetent, that are lazy, that are biased. You can use these themes in your closing argument, but he weaves this in, as you will see, in a very beautiful way to really highlight the incompetency and the corruption of the police that he perceived in this case.
They won't rush to judgment. They won't be bound by an obsession to win at all costs. They will set about trying to apprehend the killer or killers and trying to protect the innocent from suspicion. In this case, the victims' families had an absolute right to demand exactly just that in this case. But it was clear, unfortunately, that in this case, there was another agenda. From the very first orders issued by the LAPD so-called brass. They were more concerned with their own images, the publicity that might be generated from this case, than they were in doing professional police work. That's why this case has become such a hallmark. And that's why Mr. Simpson is the one on trial. But your verdict in this case will go far beyond the walls of Department 103, because your verdict talks about justice in America, and it talks about the police and whether they're above the law, and it looks at the police perhaps as though they haven't been looked at very recently.
This rush to judgment and the corruption theme goes throughout, and he tries to show not only that they were rushing to judgment, but they did so in an intentional, deliberate, biased way to frame O.J. Simpson. Now, whether he was framed or not, I don't know. I'm not a witness. I wasn't even in LA around that time. I surely don't know what happened. This is about creating reasonable doubt based on the facts and based on the evidence. When you have a police department that is doing things that are corrupt, that are racist, that are wrong, that are bad, then you have to highlight those things. But you have to make sure they're there, okay? You just don't go in like some lawyers do and claim that every police investigator is corrupt or dirty, bad, didn't do their job right. Okay, if they did their job, then you lose credibility and you look like an idiot because you're in there attacking a good quality police officer who's not corrupt. And then you look like you're just making up stuff and you have no credibility. OJ had obviously a target painted on his back. Maybe because he did it, maybe because he was OJ Simpson, maybe because the police are corrupt. All those things in a mixture of them could be true. I don't know. Again, I don't know what happened in this case. I do actually have some doubts about a lot of things in this case. But as we go through this closing, and I'm going to wrap this up now, I'm going to break these down into about 30-minute chunks. But we're going to be breaking down these themes as we continue to watch this closing. And we're going to then do other famous trials as we go. So please subscribe, like the video, share it. If you're a law professor, law student, or someone who's interested in closing arguments, or just, a true crime junkie, this is one of the best presentations that I've ever seen, if not the best. And that's why it's kind of a masterpiece to watch this. A lot of brain power went into this closing, and then we had a true master delivering the closing. Again, put your bias aside, whether you like Johnnie Cochran or not. He is one of the greatest trial lawyers of the last century. You can learn a lot from just this closing argument that he did, and we're going to try to bring that all to you with commentary as we roll these videos out. Subscribe, click like if you like it, and share it, and watch these in your law school classes. And I hope you enjoy. Take care.